Well, it is 2:30 and we are here today for our guardianship webinar. As you know, I'm Liisa Speaker, and today I have with me Grand Rapids attorney Kristen Wolfram. Kristen does family law, child welfare, and guardianship cases in the trial court, and she also has done them on appeal as well, and she serves on the family law section amicus committee with me. So welcome, Kristen. We're really happy to have you here today. So when we started planning this out, I was like, well, yeah, I've worked in a couple guardianship cases. And then when I sat down, like there's been a lot of cases over the years, and they're all really interesting, but also they're difficult in that there's so many complexities to guardianship cases. And so Kristen, we'd like to start off by just kind of, if you could help us understand the different types of guardianships, just as a starting point, and then we'll jump into some of the issues that we've been dealing with, and I think a lot of our audience has been dealing with as well. And what I did want to point out was that we do have the chat function and the Q&A function. I will be following those to make sure we get those questions asked, and to the extent that we miss something, we do try to answer them after the fact, because sometimes there's just too many questions to get them all answered within the context of 1 hour. So Kristen, start off by telling us about the different types of guardianship.
Sure. So probably the easiest type of guardianship to talk about is a limited guardianship, and it's kind of a thing unto itself, because it's very well defined in the law, and it's very well described as far as it goes. So a limited guardianship has to be voluntary. There's required to be a parenting plan. It can be done for a number of reasons, because you want, because you're going to jail, or because you're going to want to have the child attend a different school district and you're moving out of that district, or something along those lines. There's, a hearing to make sure that the person granting guardianship knows that their rights could be terminated if they don't follow the plan. And then there's a way to terminate that that's also in the statute. So pretty simple and straightforward as far as limited guardianships, and they do not convey additional rights such as the right to custody like we have in the other issues. So the second one is really what we might call a regular guardianship. And it's, there's two sort of different kinds to that, which is just temporal, right? So there's temporary and a full guardianship, and the temporary would be in the sense of sort of like an ex parte. We might understand it to be like an ex parte granting of the guardianship until we can have the full hearing, and then the full hearing. But the temporary and full guardians have exactly the same powers. It's just a measure of how long that guardianship will last, which is generally until there can be a full guardianship hearing. And then once they're a full guardian, that is actually under the law, it's unending. It can be forever. And then finally, there's we're calling for our purpose right now, we're calling them regular guardianships, the temporary or full guardianship. Are those always under EPIC? Yeah, that would be the guardianship under EPIC. Okay. So under a 5204 standard. And then what we would call something sort of separate, like a juvenile guardianship, is essentially that's less of a proceeding as a result, right? So a juvenile guardianship would be under 712A, and that would be sort of the result of abuse and neglect proceedings, right? So anyone, but a lot of times and most often it's the state or DHS moving for a guardianship because of abuse and neglect. And the guardianship is one of a number of remedies under that. So if you move under 712A, you could result in having a guardianship for a juvenile, but it's not exactly this. And the powers might be similar, but it's not the same as the EPIC guardianship or regular.
So as we're talking about this, I think what occurred to both of us is that a lot of the issues we're seeing on appeal and the problems we're seeing in the trial court are typically arising out of the EPIC guardianships. And I think, going to your comment a minute ago, the limited guardianship and the juvenile guardianship provisions there's a lot of statutory provisions that govern what can and cannot be done. And there's a lot more holes in the statute when it comes to the EPIC guardianship. So I think we're going to spend most of today, unless people have specific questions about limited guardianships or juvenile guardianships, I think most of everything we wanted to talk about today really are going to be arising out of the EPIC type guardianships. So I was going to start us off by talking about problems that occur at the initial obtaining that guardianship stage. And so just as one example, I had a case that we did on appeal that let's step back for a minute, because sometimes I represent parents in these proceedings. Sometimes I'm representing a family member who hopes to adopt the child. I haven't been the LGIL, but there's also an LGIL often involved. Kristen, I think you have represented maybe both sides in different cases as well.
Yeah, so I would say I primarily, I've gotten the most experience at representing parents who are fighting guardianships. That's happened a couple of times, but I certainly do take the cases where we've got guardians too. I mean, it'll probably come out in this that I appear to be biased, and I do think the statute itself is unconstitutional, but that does not mean I don't recognize that there is a need for this kind of statute in some fashion, because we do have kids that are being left without, care and custody, and there's ways to do that. But I both think there's other ways to do it, as well as if we are going to do it this way, there's got to be a better way under the statute.
Yeah. So, I mean, on one hand, we have the guardians who are oftentimes family members, oftentimes the grandparents or a sibling of the parent who are stepping up because that parent is just their life is a wreck. They may not be available. They may have disappeared, and they're stepping up to take care of a child. And so they obviously feel very invested in the process, and they want to protect the child. And then on the other hand, we have the parent who maybe did have a mess of a life and then, have worked to turn it around, and they feel like, okay, now that I've made all these improvements, I should be able to have my child back. And so the question is, what happens with the child? But in one of the cases I worked on, there's an issue of notice and lack of notice, and we ended up getting a reversal and appeal. And I did want to talk about notice issues a little bit with you. So with the EPIC guardianship, you have to notify the other side about, the initial obtaining that you're actually seeking a guardianship. And in our case, part of the problem was the grandfather said, we didn't tell her because we thought she would pick up the kids. So, I mean, yeah, I guess technically, but then that's why they're often done they're done really quickly. So it shouldn't have been an issue. And then the second time there was notice for the full hearing, because you get your temporary, like you said, they're all the same rights, but you move from a temporary, because the temporary doesn't last very long, to a full. And in the full, they didn't do notice because they mailed it to her address in Florida, knowing that she had already left Florida and was heading back to Michigan.
Yeah, that's actually really common. I've got a case exactly like that where the parent was actually living with the grandparent and the child, and then grandma kicked out the parent and mailed notice to her own address, knowing that he wasn't there.
That was officially the last known address, and I think there's some obligation. So, I mean, if you are the guardian and if you want to be the guardian and you're trying to protect this child, you still have to make sure that there's an attempt to give proper notice. And maybe you don't know where they are. And that's, Kristen, can you tell us, what do they do if they really, their child has, their adult child has disappeared? They maybe they think, well, maybe they're in West Michigan. I'm not sure. But if they really don't know, what would they do to give notice?
So, I mean, I guess I'll take this opportunity to just mention this is one of my big criticisms, because certainly, like I said, I do recognize the need for this, because that would be the circumstance where this is necessary, where the parent is in the wind, right? Where we don't know where that child is, or the adult child, the parent in this case, we don't know where they are, and we give notice in the same way we give other legal type notice. And then we know they're not going to show up because they're not going to read the legal news where we published it. Or maybe I've heard some chatter about Facebook, services and things like that. Maybe we get that going. But the truth of the matter is, it's subject to the same. And actually, I'm doing this in the one case where I'm representing the guardian, is we've applied for alternate service. So we are going to apply for Facebook service and see what we can do. But we didn't do that until we did get the ex parte temporary guardianship granted. For exactly that reason. Like I said, I understand that there's that need to get something in place so that the parent doesn't pick up a child. But to me, that's exactly my point, where there's the abuse and neglect proceeding. So we could move for a guardianship under 712A, any person. So even though it's traditionally done by DHS, any person who's interested in the welfare of the child can do that. And if you do that, we say there's a neglect or abuse proceeding here that needs to result in a guardianship. I have no problem with it. There's no constitutional issue with that, because it carries the protections it's supposed to. 52042B doesn't.
Right. Okay. So one of the things, the problems that the initiation of the guardianship leads me to ask you about in re orta. And orta is a case, I think you know a little bit about it. You, I think, wrote the amicus brief for the family law section. It's
part of it.
Michigan Supreme Court, and the Supreme Court has granted a MOA, which is a mini oral argument on application, where they request specific briefing on various issues. And so I think it might be helpful, because we know that this is pending in the Supreme Court, if you could just spend a couple minutes telling us about the order case, what
Sure.
happened there. And then obviously the Court of Appeals decision, I believe the family law section is aligned with the mother who won in the Court of Appeals. So
Right.
where are we right now with the decision, and what, what's out there for the future?
Yeah, super briefly, it's the facts of this case are pretty similar to a lot of 52042B. Just to be clear, like I'm going to say that a lot. 52042B is the guardianship statute. So just for those following along. Young mom had 2 kids, left them with grandma on and off for periods of time. And at some point it just sort of became this push and pull of contentiousness, where eventually mom was trying to pick them up. She had a lot of addresses. She moved here, there, and everywhere. And grandma just stopped wanting to give them back. She kind of gave mom a bunch of chances and didn't want to do that again, except that mom had rented an apartment, had tried to get her life together, and had really started to move forward on establishing a place. She was in her mid-20s by this point and had the ability to care for the kids. Grandma had tried to keep the kids from mom and filed her guardianship, because one of the provisions under 52042B is that the children are in your possession at the time you file the petition. So as soon as she could satisfy that, she went ahead and filed, and that sort of puts a pin in that factual situation. And as long as you satisfy that, the court can then take jurisdiction and grant that guardianship to the guardian. And ultimately, they did in the trial court, and then she appealed. The Court of Appeals said, as they kind of do, they sort of hone in on one particular issue, because no one wants to get rid of this statute, but it does have a lot of problems. So they hone in specifically on the fact that it's a temporary living situation. So in this case, they took, essentially the facts that establish that mom never meant for the kids to live permanently with grandma. They focused on being a temporary situation. And because of that, said that grandma couldn't ultimately have met the jurisdictional standard in the first place, and therefore the court should never have granted the initial guardianship. And I'll take this point to note really quickly that is a problem with a lot of the cases, is that we have to go back and attack that initial grant of guardianship for jurisdiction much later by leave. And that's why there's a dearth of cases, because by the time we get around to what do we do, because the statute doesn't have those provisions, all we have left is to go back and attack the initial guardianship petition.
So I do have a question about this temporary versus permanent, because couldn't a parent say, well, it was meant to be temporary. Yes, it was 3 years, but that's just temporary. I mean, from the child's perspective, that's not fair to the child. Did the order court at all explain what temporary meant?
No, and it actually kind of goes against. So the other case, the other sort of primary case right now is Deschênes versus Saint Germain, which was a 2003 case. And in Deschênes, again, I think the Court of Appeals punted a bit and said, basically what happened in that case is mom was living with her parents and the child. So mom, grandparents, and child were living together, and mom passed away. And dad came at the funeral and tried to pick up kids, and grandpa said no, filed for guardianship. Proceedings happened again, because that is what happens, is we try various things to try to do kind of a halfway thing, get dad some parenting time, rehabilitate, whatever, which the court does have the power to do once they take jurisdiction. But ultimately we go back, because there is so little in that statute to attack. They went back and did an attack on the original grant. And the Deschênes court said that there was no permission because mom was dead, so she couldn't give permission, and dad didn't give permission at the time the guardianship, I think it's the issue of guardianship arose, is their language. So they said there was no permission to permanently reside. And then we have Orta, which says, well, it was a temporary living situation, even though it was back and forth and it was never meant to be permanent. So we don't really have a clear answer on that. And that is another criticism I have of the order. There's no time limit required. So it could be 2 weeks, it could be 2 years, and there's only sort of factual distinction can matter.
Got it. I've been putting messages in the chat thinking I'm sending them to everybody, but apparently I'm just sending them to
to me,
my marketing director. So I apologize. I'm going to I'm just trying to share a little bit of information as it comes up. There we go. So I apologize that for people in the audience who might have wanted some helpful citations. I'm trying to share some stuff with everybody. Thank you, Delaney, for telling me that. I think it went through this time. Okay, so there's so many little pieces of this puzzle, and
Yeah.
sort of have an outline of what order to go into, but I feel like we need to jump out of order just a minute.
Sure.
So first of all, the comment you made about ORTA just a minute ago about how the child must be in your possession of the prospective guardian in order for them to file that petition, made me think about your Vasali case.
Yeah.
So I think, and that was a published decision that came out last year. So I really think everybody needs to make sure they're aware of it. And if you could just share just a couple of how much ever you feel like sharing with us about the Vasali case and what happened there.
Yeah, for sure. So it's for sale, but that's okay. So I'm just going to say it for sale.
Sorry.
Yeah. So my client is Adam Versale. He had 2 kids. He did have a bit of a troubled history, very young when he had these kids, and ended up in jail, prison, I think for a bit, 5 years or so. And during that time, the girlfriend and mother of the children lived with his mother, so paternal grandmother. And those guys lived together until Adam got out of jail and began living with them. And he got joint custody. So he's a joint legal custodian, which is required for guardianship. And then mom passed away. So grandma and the girls were still living together. Adam found himself in the position of needing to sort of get out and start fresh, get some mental health treatment. He had no longer so he completed some mental health treatment, and he had no more criminal history or anything like that. And actually, I mean, because he was in jail, he hadn't been with the kids, but there was no CPS history in this case or anything like that. So there was nothing to indicate that he couldn't care for these kids. He just wasn't present at the time. He set up his life in Texas, and after that, had the kids down for breaks and summer. The kids spent all summer with him the year before. Did go back to grandma's and decided he wanted the kids to come to Texas at the end of the school year, so that everything was arranged. And when grandma found out in January, she actually filled out the guardianship papers. And then come May, when it became a reality, she filed the paperwork on like a Thursday or Friday and took the kids to the airport on Monday. And so while dad was living with the kids, about 2 weeks later, he got served with notice of his guardianship hearing.
So they are technically in her possession the day before they went to Texas. So she satisfied the statute for that part of the statute because they were in her possession, even though the very next day they were gone.
Correct. Yep.
Okay.
Even though right after that they were gone, they lived in Texas. And there was no indication that there was a problem. Dad had he had a rental home that he'd been living in for 2 years, had a stable job for that 2-year period of time. And during that time, he had taken care of everything that the kids needed remotely. So he would call in for doctor's appointments and say, my mom's going to take them, and, anything you need me to sign, let me know and I'll take care of it. And he would get briefed. The school was the same. So he would come up, he would take trips up here and he would go to the school. He would sign off on things the kids needed. And then he would, go back to Texas he would do that on his breaks. And so she never needed any quote, like she wanted him to give her power of attorney and guardianship. And he didn't want to do that. He didn't want that. He insisted this would be temporary, and it ultimately was temporary, obviously longer than in some of the cases, but not as long as others. And so the court granted the temporary guardianship and then the permanent one after a hearing. And I tried a number of different remedies, like filing motions for parenting time and things like that, which are technically permitted but not required under the guardianship statute. The court declined to answer any of those motions, and I filed the delayed leave for appeal. That was granted. So then it ultimately resulted in a Court of Appeals opinion, which agreed with me that a parental presumption should apply to a guardianship statute, which hadn't been decided before. However, there's significant issues with the opinion, including the fact that it somehow, and this is technically in the dicta, but still not great for future cases. It says that essentially that if you come under the purview of 52042B, then you are an unfit parent because you failed at that point to provide for your children.
So I guess I take issue with that, because isn't the whole point of placing a child with, a relative because you aren't able to take care of them shows that you're fit, because you're making decisions about the care, custody, and control of the child. And I do want to talk about fitness in a minute, but I think we need to finish up the chain of thought here. This 5204B, 2B, right?
Yeah.
There's this whole issue about the elements of that statute, and some of it has, the standing elements about what it takes to be able to file. And in the Versailles case, she did technically qualify, because the statute says the parents permit the minor to reside with another person. That happened.
Check.
Does not provide the other person with legal authority for the minor's care, and the minor is not residing with his or her petition when the parent when the petition is filed. So the question in that, and I think part of the question in your case was, well, does he not provide the other person with legal authority for the minor's care and maintenance? And what does that mean? Do you know what it means?
Yeah, so a little bit. And I want to stop kind of briefly. So one of the issues, when you said you have an issue with that, I would agree. And one of the things I argued in my case was because if this was under the juvenile proceedings for a guardianship, the court could not take jurisdiction in for exactly that reason. So under the 712A, if you place a child with someone and they receive adequate care, the court cannot take jurisdiction. Whereas in this case, even though the child received perfectly adequate care, the court still took jurisdiction and stripped the parent of the parental rights. But as to the issue about legal authority, that is one of the elements that I use. So the Versailles case, now I did file a leave I filed an application for leave to the Supreme Court. So we'll see what happens there. But one of the issues I did say in that case was with regards to this authority, this alleged parental authority. So there was a case, and we talked about it earlier. I found it. It's called Trudeau v. Martin. It's in Re Martin, which is referenced in a couple of places, that a power of attorney may not even be enough to satisfy legal authority. And there's actually a more recent case that I didn't find, but I believe it's 2016, unpublished, that mom gave a power of attorney and a couple of other things, but the power of attorney expired. And so they also found at that point that it did not qualify for legal authority. And certainly my argument is, what did she need legal authority for at that point, right? Because it freezes, by the wording of the statute, it freezes that factual situation in time. So the kids were with their dad at the time. Potential guardian would only need that legal, it was looking backwards, right? Whether or not she needed legal authority in the past and didn't have it was enough to get her present guardianship. Which, like I said, to me is an issue, because she didn't need it in the past. She didn't need it in the future, but it was an element, and it was found to, there's no question. He did not give her legal authority. And so that element was satisfied in my case.
So going as part of the standing analysis, I had a case once where my client, needed help from her parents. So she brought her kids to her parents' house, and then, I'm sorry, I'm getting my cases confused. Okay, switching cases. The standing issue. Sorry about that.
Yeah.
The mom and dad were joint legal custodians, but the kids were primarily at dad's house. Then dad dies unexpectedly, and the grandparents, the dad's parents, take the kids, and then they seek a guardianship. But in my view, they did not have standing, because she was now the sole legal custodian. She had a parenting time arrangement before. It's not like she had supervised parenting time. And she did not give them permission to have the children. They took the kids. And one of the elements of 52042B is that the parent permits the minor to reside with somebody else. So if you let them go for an overnight, that's not residing, right? That's the whole temporary versus permanent distinction. And even though she objected to the initial guardianship, because of a lack of standing, before the hearing was held, the grandparents filed a third-party custody action, and then the whole guardianship was shut down. So I think it's really important for the audience to understand the implications of a third-party custody case. And it's a terrible thing. Yeah. I think if you have constitutional rights that have been violated, and then you're not even allowed, you don't have any venue in which to complain of that, because you can no longer talk about anything in the guardianship case.
It specifically pauses it, right? So when you file as a third-party guardian for third-party custody, the custody case takes precedence and everything in the guardianship case is paused. I have had success. So I did have a recent case exactly on that issue, that the court did dismiss the custody case until I finished arguing my guardianship case, but only because I was lucky enough in this instance to have enough time to file for the guardianship. So there was sort of like this standing motion that hadn't been ruled on by the time the custody case was filed, and it was all in the same court. So the court did the second judge.
You had the same judge?
Actually, we didn't. The custody case got assigned to the family court,
Right.
but the family court did dismiss it and said that they could refile after the guardianship case was decided. But like I said, I think that was only possible because I had already objected.
But you had filed, because you had objected in the guardianship case, but then you also filed a motion in third-party custody case? Okay.
Yes.
That's a really good tip. And I think technically you could appeal the initial guardianship decision at that point, because you don't have a decision. You don't get a decision on your stand. That's the problem, though. You have an initial decision, but all your objections that make the record of why there's no standing aren't part of the quote-unquote record for appeal. And I can't remember why we didn't appeal that initial guardianship order in that case. It might have been too long or something.
Well, a lot of them are too long. Yeah, exactly the point, because we try these sort of interim remedies because they might be we can get a motion date sooner than we can get an appeal. So you try these interim remedies, but at that point, like a lot of these cases end up being leave for appeal because they're so long into the process, and that's sort of your only resort.
So a lot of times what happens is, a guardian, we have a guardianship, it's all proper. The guardian, who's oftentimes a grandparent, is taking very good care of a child. And, some time has gone by. Now we're talking about, it's been often more than 2 years, and they're being told that by the guardianship court that they need to seek permanency for the child, or they just want to have some resolution in their life. So maybe 2, 4, 6 years go by, and the guardian finally files a petition to terminate the parental rights. Because can you tell us a little bit about the statute under the juvenile code that allows a guardian to seek termination of parental rights?
Yeah, so under the termination of parental rights, we're actually going to talk about the parent's fitness for the first time, right? So under that would be required to show, and that's a best interest standing, right? So it's fine, or a best interest finding. So they actually do get to finally conduct a best interest, which I guess it's interesting to note they have not done yet, right? So even though we have a guardian several years into the process, no one at that point has conducted a best interest analysis of the child.
There's no best interest analysis when you get the guardianship, but there is if you try to terminate it, right?
Yeah, so right. So for 5204-2B, you satisfy those 3 things, the court may grant it. So they're not required to then go on and do the best interest analysis. They could, but they're not required to. They may. But usually by that point, it's pretty simple to tell, right? Like if they've been able to satisfy those other things, those 3 provisions, and they pause it at that point in time, you've got a parent not providing for their child because they're letting them live with someone else, then they get a guardian. So yeah, not until we get to a point of finding of the fitness of the parent. And that is sort of an interesting, to me anyway, chicken and egg sort of process too, because now we're talking about fitness. But for instance, in my Vercel case, they kind of point out that the 2 things. There's no requirement for finding of unfitness, right? So in a history of cases beginning in like the 70s, I think 1976 was the first one, which stood for the proposition that unfitness wasn't required to overcome that parental presumption. So Troxel and Hunter, so Troxel, the US case, and Hunter, the Michigan case, they actually just declined to address it because it was beyond the scope. So I think actually in my case, in my opinion, they say, well, it's well established that, we don't have to have we don't have to establish unfitness before we get to the finding of the guardianship. But that's actually not true. That's not what the history of cases says. It says that it was beyond the scope of Hunter and Troxel, and we weren't going to talk about that. And it turns out we just never have. And then and that kind of goes all the way up to, like I said, my current case where it says what they ended up saying was, by coming under the purview of 5202B, that, and this is the quote, respondent had essentially stopped providing adequate care for the children. So there's no moment in time. So I guess what I'm trying to say is that by the time you get a guardianship for 52042B, you are an unfit parent, according to my case in for sale. And then they should be able to go ahead and springboard right into terminating parental rights, certainly after the best interest factors. But the presumption, I don't think, is any longer in your client's favor at that point, even though it technically should be, right? Under the law, they're supposed to get a presumption, but they don't have the fitness anymore, so they get no presumption.
I don't think the juvenile code gives a presumption, for the adjudication, and I put the statutory site in the chat. It's just the 2 years of the no contact, no support. I mean, I'm paraphrasing, that's not exactly what it does. And then once you have established jurisdiction, there are similar grounds for termination that the court could use to terminate parental rights. And then it's going through the whole, just like any other juvenile code case, you do the statutory grounds, and then if there are statutory grounds to terminate, you then go to the best interest. And so finally, at the very end of the juvenile code proceeding, you examine the best interest. But I mean, to your point, in the guardianship case, there isn't anything about the best interest when you're getting the guardianship, although there is if a parent is trying to terminate it, they have to show best interest. Now, I think it's interesting. I have an outline. You said you should put a note in here about the Block versus Galbraith case. I think that was your note. Okay, that was interesting because that was our case. Oh, it was a mess of a case. And I just, if you want to talk about it, that's fine. But it was like one of those things where the guy was my client was the father. My client was actually the grandmother and her son, the father. So I represented both of them on appeal because they were aligned with each other. And my client, the father, was in prison in Texas. But then during the course of the proceedings, he was able to come back to Michigan. And he had been released and everything for serving his time. But the dispute in that case was between the paternal grandmother and the maternal grandfather. So we had two, when the mother died, the grandpa steps in. So it's basically two grandparents fighting with each other. And at the time, dad was in prison. So like he is stuck, he can't really do anything. And the trial court in that case awarded and there was a maternal grandmother as well. The trial court awarded joint legal custody to two guardians in two different households. And part of the dispute was, once he got out of prison, he was trying to get parenting time. So I don't know if you had something specific you wanted to share about the case, but like these cases are so messy.
No, it is. And I think that's a great example for where the courts kind of try to fashion a remedy out when like they try to sort of fashion almost a joint custodial situation when the law is not there to support it. In my opinion, it just isn't. There's nothing there. So if you've got maybe two people standing in the place, if they get to the point of standing in the place of a custodial situation or under the Child Custody Act, maybe, but we're not there with the guardianship. There's nothing under there that allows that.
So let's talk a little bit more about the statutory requirements to have the termination case for when you're a guardian under an EPIC guardianship, which is 712A 2B6. And that is where you have 2 years of I say 2 years, no support, no contact. The Court of Appeals has said, and it wasn't an unpublished opinion, but it basically is analyzing the statute, that the guardian has to show two things. They have to show that the parent had the ability to support or assist in supporting the minor for 2 years and failed to do so. Or if there was a support order, that they failed to comply with the support order. And then the other thing they have to show is the parent had the ability to visit, contact, or communicate with the juvenile and substantially failed to do so. So on moving just to the child support part of it, if you don't have an order, you just have to have the ability to support and don't do it. But if you do have a support order, then if you don't substantially comply. So the thing that happened in one of the cases that we were going to talk about is that the father had a support order. It was for $0. And he substantially complied with his zero support order because it's really easy to do. And the Court of Appeals said that meant the trial court lacked jurisdiction to have the guardian pursue the termination case because he did substantially comply. And there was an argument made about the problem is the adoption code has language well, this is not an adoption case, but the adoption code has language about if a zero support order doesn't count, that you can't use a zero support order, and that legislative language was fixed, but it wasn't fixed in the juvenile code. So I think we have some epic changes that need to be made, and there's some changes in the juvenile code, because if a parent is not doing anything to support their child, but have 100% comply with the zero support order, the guardian does not have jurisdiction the court does not have jurisdiction for the guardian to pursue the termination case. So my question to you in that factual scenario, Kristen, is what is the guardian's remedy in that point? Is there only remedy to go ask the court to order support, and then they have to wait for 2 more years?
That's an interesting, it's a really interesting question. I was thinking about that from both sides when I saw it, because this is another complaint. And I guess just to reiterate, there
Oop, you're cutting out.
Court or things like the parent, like a parenting plan and a support order and things like that. It's not required. And like I said, in my case, I did ask the court to order those things, and they declined to hear it. So they were never, we would go for that, and the court would end up just finding my client in contempt for not being there over and over. So, there was no support order, and there's nothing required. And so I would think that the remedy for the guardian here is to request a parenting plan and support order. And, because here is it, right? The whole purpose, and, the Court of Appeals in Burstall said it, and all of these cases talk about the purpose of this law, and particularly 712A, which is another constitutional tension I have in my case. They're supposed to be for reunification of the parent and the child. The whole law is supposed to point towards reunification, unless, of course, it's not in the child's best interest, right? So I think we have to at least give them a shot, establish at least an hour of parenting time a week, or therapeutic parenting time where we're meeting with the counselor. And if they don't, because we know they may not, chances are in these cases, they're not going to, then you can say, look, they didn't comply with this order. But in the case of 52042B, they're not required to. So if we don't have any reason to have a plan, that frustrates the guardian, but also frustrates the parent who's trying to get some door back into their child's life.
And when you're referring to the plan, I think you're referring to a limited guardianship that would impose requirements on the parent.
I would say that we don't have that requirement, but we should.
If you said it earlier, I apologize. Do you know the statutory site for the limited guardianship part offhand? And if you don't, we'll pull it later and share it with everybody.
Yeah, I do. It would be, but it is required. So under the limited guardianship, you have to have a parenting plan. It's required. It's right on the SCAO form. If you do it by form, you must have one. It's right in the statute. For 52042B, there's not at all. So there's no guarantee of parenting time, no guarantee. I mean, you can move for support, which surely guardians could do and are entitled to. I'm not saying they're not, but there's no reason, there's nothing required that says the court may. So it's 5204245. And so section 5 of that same statute says the court may grant, other support, parenting time, or other relief, but you don't have to.
What I'm gathering from this conversation is that a limited guardianship protects not only the parent, but it protects the guardian. So if the parent wants to make sure that they have a chance to, continue a relationship with their child and have an opportunity to reunify with the child, the limited guardianship can provide a tool to them for that.
Yeah.
And if they fall off the edge of the cliff and they aren't able to do anything, it protects the guardian and the child who has a parent who perhaps has disappeared or maybe dealing with a drug addiction and is not doing what they're supposed to. It enables them to file a petition to terminate parental rights so that the guardian can then adopt the child. So it's really, it sounds like because there's so many flaws as we're discussing today with 5204 2B, or that it protects both sides. It's in everybody's interest really I
totally agree with that. In fact, I mean, that's my resolution in my most recent guardian case, which I had the chance to almost litigate with, but I had a great opposing counsel on the other side. That's what we did. So she filed for a 52042B. I immediately said, look, I'm going to get this dismissed, but we could work together and do a limited guardianship plan. And it has everything in place. And so I imagine that some folks in the audience might think like, well, just do that, right? But we do actually have case law, again, under 712A, that says we do not have to get the courts involved in order to protect our constitutional parental rights, right? So as parents, we shouldn't have to do that. So I'm still going to say but it is a great remedy. I think as practitioners, we should absolutely be using limited guardianships more in these circumstances and recommending them as an alternative.
So, and with the limited guardianship, because I didn't focus on those statutory provisions, is there a time period, like the parent misses one parenting time session, that doesn't mean that the guardian can go seek to terminate parental rights? Is there, how much time do they have to not comply before like they're gonna like really something's gonna happen?
It's a substantial compliance standard, just like anything else, but it also really has to do with how you craft the plan. So if you put in the plan, there can be reasonable parenting time, and calls, and they're having reasonable parenting time, I think you're good. Because you can use the plan that's laid out, or obviously you can attach an addendum, and it's, it allows you to do that. And if I recently, the most recent one that I'm doing it's a family. So the brother is going to take guardianship of the daughter while mom goes through treatment. And he initially had checked, Monday, Tuesday, Wednesday, Thursday, Friday. And I was like, hold on. So we went back and revised it and say, look, mom's going to have, Saturday and Sundays for sure, supervised parenting time. But in the plan, we said, all other times that the parties can agree on that that uncle thinks is safe. And so you can craft a remedy to have substantial compliance. But if not, and we put drug testing provisions in there and things like that make sense to protect the child and the guardian. And if they don't comply, I presume he'll be able to terminate based on those.
So turning back to another issue we've touched on a little bit, the best interest of the child. And we've already talked about how EPIC doesn't require the best interest to be considered before entering a guardianship. We had a question posted about what are the best interests for EPIC when they're terminating a guardianship. What are the best interest factors under EPIC as compared to a juvenile code termination of parental rights case?
As compared to a juvenile code, I actually think this is the progeny of case law that says that we do read those things in pari materia. So we have the same under the probate code, we have the same purpose. We aim towards the best interest of the child, and they did actually adopt them. But the case law does say that they don't have to make the same findings under the Child Custody Act. So we have our 14 or whatever, is it 14 or 15 factors? Yeah. The couple of catch-alls that don't always apply. So you have 12 factors that we use those same ones, but they don't have to make specific findings like they do in the Custody Act.
Right. To add to your answer, there aren't statutory factors for best interest under under the juvenile code. It's all based on the case law, which is, I think, a failing of the statute, that it would be really helpful, because right now, the way it works in both of those types of cases, the judge gets to pick and choose which of the factors they want to consider. And unlike when we see a lot of family law cases, like let's just use spousal support as an example, or property division. There's case law that says, here's 12 things for the judge to consider. And they don't necessarily have to make a finding on each one like you would for the Child Custody Act best interest factors, but it's really laid out clearly in one opinion, and you can just copy and paste it and look, judge, here's what you need to consider. And you can do that in the trial court as well. You can present your evidence based on this list of factors, but we don't have that under the juvenile code or guardianship. It's there are cases, and we cite 2 or 3 cases if we're trying to explain to a court what the best interest factors are. And of course, there's no requirement of the judge making findings on any particular one. So I think that's right. It makes it hard. Why is it less important to have specificity for the child when it comes to termination or guardianship than it does for the Child Custody Act? I don't know. Maybe there is a reason, but I don't offhand, I don't know what it is.
Yeah, I would agree. I don't know. And I don't think it serves, I personally just don't think it serves it doesn't serve their interest to have sort of a moving target, especially with all of the other holes that are in the statute. So if we don't have a parenting plan so that we can point to those failures, if we don't have the interest, that we end up with what I thought was the outcome in my case was that the grandma was a better guardian, and so she got to be the guardian rather than the dad. So I think that's, it ends up being a moving target, and I don't think that's fair.
Right. There's other like issues that have come up in guardianship cases. And one of them came up, I think it might now have been 2 years ago, I'm losing track of time, but the published Court of Appeals decision in I am Long, I know you're aware of. And just a quick recap, that is the case where a guardian sought to terminate parental rights. And the Court of Appeals in a published opinion said, oh, she was trying to terminate the parental rights of the putative father, right? I think maybe the mother had passed away, or she had released her rights. So mom's out of the picture for whatever reason. And there's a putative father, and she needs to terminate the rights so that she can adopt the child. And the Court of Appeals in a published opinion said, well, a parent under the juvenile code does not include a putative father, a putative parent. Therefore, the court cannot terminate the putative father's rights under the juvenile code, and there was no remedy for that guardian. So I don't know if you have any, I have a couple of questions about the case, but I don't know if you have anything you want to say about the case first.
I think that just kind of goes along with our discussion, is that I think that, that properly assuming jurisdiction, based on the wrongful assumption, should apply to all cases, right? We should be able to go back, because that is what we find in these guardianship cases, is that there could be all these problems, and our only option is to go back and attack it ab initio, right? Like from the first grant of jurisdiction in these cases.
So in that case, I mean, when that case came out, and it did go to the Supreme Court even had oral argument on it, then I think they declined to decide it. So we didn't get any more clarity than what's in the Court of Appeals published opinion. But I remember when I read that case, I was like, well, juvenile courts terminate rights of putative fathers all the time in the context of termination proceeding, in the abuse and neglect proceeding. And I struggled with understanding why it couldn't happen with the putative father when that's what the practice has been. And what I've been talking to other colleagues, they've kind of basically accepted the case to mean that it's really narrowly construing it just for guardianship cases. So I don't know if you read it the same way, maybe I was misreading it, but basically we're saying, okay, if you're a guardian seeking to terminate parental rights, you can't terminate the rights of a putative father.
I think there's two things that come to mind. And one is that for the lack of all the other kinds of definitions in the case, under the probate code, there is a definition of parent. And I recall that case being really specific about digging into literally the definition of parent under EPIC. And the second, I guess what comes to mind is, and I don't know if they talk about this in I am Long specifically, I don't recall, but like the parental presumption, again, like we're talking about constitutional rights of a parent here. And so when you've got when you've got a custodian or a guardian, we haven't had any application of the parental presumption. So we've got a potential biological father. Other cases say, like other, and I can think of the facts and not the name of the case right now, but other cases say that, a parent should have no bars to the door of the court, right? The parent should be able to walk into the court under any circumstances and say, I deserve to be able to have my kid. The case I'm thinking of, if anybody knows the name of it, is mom died, dad was sort of estranged from the family, and the child lived with grandma and grandpa. And then the dad came in, and the court said the court had sort of put them in joint custodial position. And then at some point, about 2 years or so after dad had sort of reintegrated into child's life, dad wanted to move for a change in custody, and grandparents said, no, there's been no substantial change of circumstances, right? So they tried to apply change of circumstances, and the court actually said, no, dad doesn't need to change circumstances here. He doesn't need that. There's no bar to the doors of the court for a biological parent to walk in and say, I want to have the full custody of my kids. It worked for us temporarily, but grandparents, you got to take a back seat now.
I'm hoping somebody on the chat remembers that. I know, Dennis, I remember that case, and I didn't write it down on my list of cases to discuss today, but that was and I can't remember if it was published or not. Maybe it was unpublished, which is why I'm having trouble.
I think it was, and it was out of Wayne County. I'm trying to find it for you.
So, but I think there's a difference. You're talking about the parental presumption, but putative fathers don't have the same constitutional rights as
That's true.
Because they're biological. It's not the same as a legal parent. And certainly when the putative father hasn't done anything to support the child or whatever. I think the I.M. Long case, and I wasn't involved with that case directly. So, but I think that there was by a putative parent who wasn't in the picture. And the question that came to my mind is, what if you're the guardian because your own child has died and we don't even know who the dad is? I mean, is there a way, how do you terminate his rights so that you can adopt when we don't even know who the dad is? So I don't have any answers. I just,
yeah, I guess you're right. I guess I would agree with that, especially because you might say that you could, essentially start a DHS case in some fashion, but I would disagree that you have to, because under the probate code, it says any interested person. So I would think you could be able to do that. And I would disagree. Now that you bring that up, I disagree with the ruling too.
Another situation that I've seen arise, and there's always like all these unique things that come about in cases that nobody really thinks about. And then you try to do research and find out there's no case like yours. That happens to us all the time. So don't feel bad if it happens to you too. But there's a case where, the guardian again is seeking to terminate parental rights of their own child so that they can adopt now their grandchild. And if the trial court denies the termination, let's just use on the best interest, for example, can the trial court then bring in DHHS to help with reunification? Can the juvenile court do that? My position is no, they can't. And the reason is because the juvenile code doesn't provide for it. EPIC does. So yes. EPIC has a provision about when you're terminating a guardianship. That was the topic we need to come back to, is modifying and terminating the guardianship. There's all these provisions in EPIC about what the court can do. The statute doesn't want the child just to be ripped out of the guardian's home and just thrown into the parent's home. It envisions that there's going to be some sort of transition, and the probate court can even bring in DHHS to help with that transition. And maybe the parent needs some, services or whatever in the context of EPIC. It's not in the context of the juvenile code. So that was just an interesting thing. But that reminded me, we go ahead. I definitely want to talk about modification and termination.
Yeah. I was going to give you two things. First, the case I was talking about is Frauner v. Smith, and it does appear to be published. And
it was published, yeah. Mm-hmm.
Secondly, I'm going to admit this, I guess, because I actually put it out of my memory for a long time, but I was involved in a third-party custody case before I even left law school. I started at the Free Legal Aid Clinic in Detroit, and we worked on a case that went to appeal. And my friend and we ended up being licensed by the time the appellate decision came out. But that case was out of Wayne County, and what had happened in that case is the dad was remarried to a stepmom, and the mom had significant drug issues and had been kind of in and out of dad's life, or of the child's life. And we represented mom. Dad had died.
The Kane case?
Yes. And we lost that appeal before I even really graduated.
I'm sorry, what party did you represent?
Amy Kane.
No, I mean, you represented the stepmother.
No, mom.
Mom, okay.
Yeah. And the court essentially found, at least in the, so it is not a direct answer to your question, because I would agree that under the juvenile code, it does not allow, they either take jurisdiction or don't. It's a yes or no question there. But as far as sort of wrap up, Kane versus Janjowski, that was me. So in that case, they did find that the court made the proper decision in allowing stepmom to have third-party custody standing in place of dad, because that was the child's home environment, and the court was allowed to sort of do wrap-up reunification things without awarding my client custody. So been fighting third-party custody for my whole career.
Okay, let's talk about for our last few minutes, and we obviously welcome any questions that people have. Just the 5209 is the EPIC provision about modifying or terminating guardianships, and I already mentioned one of them that allows the court, if it does indeed want to terminate the guardianship, allows it to do in a transitional way. Obviously, this is all in the best interest of the child. So, is there anything else you want to add to the conversation about modifications or terminations?
I guess just to point out in a way that I've kind of said it a couple of times, but just to be clear. So on Versailles and some of the other case law that, was cited to support that, like going all the way back to Hunter, they, the court said we don't have to have a finding of unfitness. Then the court also says, or I shouldn't say the court, the statute does not require any parenting plan or any requirements to be put in place. So when we look at the statute for terminating, 5209 is a best interest analysis. The guardian could have prevented the parent from having any contact with the child. So we can really be put in a really nasty situation, in my opinion, where there is no remedy for a parent to get a modification or termination under the current status, right? So if they don't ever have to be found to be unfit, then even a showing of them being fit shouldn't be grounds to terminate under the law, right? Like obviously as a practitioner, we would say like, look, they're a fit parent now, we rehabilitated our client. But based on just sort of the legal findings here, there was no requirement for a finding of unfitness. So a finding of fitness really shouldn't undo a guardianship. So that's just a really big hole in that law, in that statute, is that there really isn't. But, certainly practically, right? Like I'm not advocating that, judges aren't, with their big smart brains, aren't actually doing these cases like they're supposed to and saying what could be good for the child. But I just find a lot of latitude, like essentially it's completely up to the judge's discretion as far as I can tell.
One thing to mention about motioning to terminate or modify an epic guardianship, I mean, the statute doesn't say anything about, it's a modifiable order. So if you get denied, that doesn't mean that a year later you can't try again. Maybe you needed to get a job and then you get, you make other changes. But the standard, it's just the best interest standard, just like you said. It doesn't talk about once you have it denied, you have to wait a certain period of time. It doesn't say you have to show a change of circumstances. It's none of that. It's just what's in the best interest. And so I would think that if you've done it and failed, like you filed the motion, don't succeed, if you are going to bring it again, you probably should wait a little bit. Just like I would advise a family law client, you want to wait a little bit, do more work, to improve your situation or whatever. And so that you can make the case, make your case stronger that it is in the best interest of the child.
And as a practical point, I would just say, so again, I mean, there isn't a requirement, but under 700.52045, you can move the court for something like a parenting plan or move the court for something, some kind of goals that you could then achieve. And then, so as a practical point, a motion, I mean, just a straight motion for a parenting time or motion for some kind of, evaluation maybe, or something along those lines, whatever your particular case circumstances are, that would then, give you some kind of goalpost to get to, as opposed to just, like I said, I truly, I don't know. I don't know what you would show to terminate or modify guardianship. There's nothing in the statute that sets a standard. So yeah, I think you have to set your own.
So just to clarify, the statutory provision you just cited from 5204.25, that motion to get, parenting time or to have the parent pay support, that can be filed in a regular guardianship. It's not limited to limited guardianship. So it is a mechanism that not only could the guardian use it, but the parent could also use it.
Yes, absolutely.
Excellent. Well, thank you. I don't see, we have a question really quickly. Thank you, Martha. What we are going to do, we'll wrap this up now. Thank you so much, Kristen. We probably will try to send out some takeaways in the next few days with making sure you have the sites to the cases that we've been talking about. So you're not, like, I know if you're working on a case right now, you don't want to wait for a month to hear something about it, but we can send out a quick little citation sheet just so you have the information for the statutes that we cited and the cases we talked about. We'll get that out to you in a few days. And again,
I'm happy to provide any of the case, like the briefing and things like that for my case. If anyone's interested, I have no problem sending it around.
And keep an eye on the cases in the Michigan Supreme Court, because there's two Orda's pending on going to have a MOA, but Versailles is, potentially they might do something with that as well. So thank you again, Kristen. Really appreciate it.
Thank you so much for having me.
You too. Bye.